I intend to have lecture series as far as the Criminal Procedure Code of 1973 is concerned. With this in view, this is part 1 as far as my lecture series is concerned. Today, it's an introduction to the provisions of the Criminal Procedure Code of 1973. It's not necessary for me to make mention. Prior to the Criminal Procedure Code of 1973, we had Criminal Procedure Code of 1898, which was repealed. If at all you want to have a comparative study, you may study the earlier provisions. Otherwise, this is the right, just and proper time for us to start with the provisions of the Criminal Procedure Code. In order to know Criminal Procedure Code, as a student of law, you must be in a position to distinguish between law under two different heads. It can be classified under two different heads. One is the substantive law and other is the procedural law. What is substantive law? Substantive law is that law which defines rights, duties and liabilities of an individual. For example, if you refer to the provisions of the Indian Penal Code and refer to any one of the sections of the Indian Penal Code, like section 378 of the Indian Penal Code, which defines the offence of theft, which says, whoever intending to take dishonestly any movable property out of the possession of any other person moves that property without that person's consent in order to such taking is said to commit theft. Well, by reading this section, you come to know what do you mean by theft. You cannot take my book without my consent because that is my right, and it's your duty not to take book without my consent, and if you fail in your duty, there starts your liability as it is defined by section 378 of the Indian Penal Code. Now, if somebody commits the offence of theft as defined by section 378 of the Indian Penal Code, by reading entire Indian Penal Code, right from section 1 up to section 511 of the Indian Penal Code, it is not possible for you to know the procedure that is required to be followed from the point of view of implementing the provisions of the Indian Penal Code. And hence, right time for us to refer to the provisions of the Criminal Procedure Code. So what is this? This is a procedural law. What is procedural law? Procedural law is that law which tells you the mechanism to implement the provisions of the substantive law. So if any offence as defined by the provisions of the Indian Penal Code, by that I do not mean Indian Penal Code is the only substantive law. The Dowry Prohibition Act, the Prevention of Corruption Act, the Motor Vehicle Act, the Protection of Civil Rights Act. This is just enumeration. The list is not at all exhaustive, mind well, but there by reading those enactments you come to know what is meant by an offence. And if that offence takes place, what is the procedure that is required to be followed is nowhere mentioned in that enactment, but it is laid down by the provisions of the Criminal Procedure Code, and hence the importance of the Criminal Procedure Code. During course of my lectures, you will come to know that we shall be referring at the time of discussing the provisions of the Criminal Procedure Code, we will have to refer to many more other enactments. Why? For the simple reason, you can't learn this law in isolation, in watertight compartment independently. No, certainly not, because of the importance of it. And hence, I shall be making mention of some of the provisions of the Indian Penal Code. I shall be referring to some of the provisions as far as the Indian Evidence Act is concerned. I shall be referring to some of the provisions as far as the constitutional law of India is concerned, and similarly during course of time I may draw your attention to some of the provisions as far as the Criminal Court Manual is concerned. So let me tell you that by merely reading Criminal Procedure Code, it may not be possible for you to understand the provisions of the Criminal Procedure Code unless you have prepared as far as the Indian Penal Code is concerned, as far as the Indian Evidence Act is concerned, as far as the constitutional law is concerned, as far as the Criminal Court Manual is concerned, with the help of which only it will be possible. There are many other provisions with which I shall be dealing during course of time. Now this is just for introduction, and At the time of introduction, let me tell you, follow one practice. What I shall be dealing as far as the second part of my lecture is concerned, or part 2 as far as my lecture series is concerned, if you read that much part and keep yourself ready, while I shall be dealing with the provisions of the Criminal Procedure Code, I personally feel when you start listening to the lecture that is delivered by me, please do have bare act of the Criminal Procedure Code with you. Do have bare act of the Criminal Procedure Code with you. Do have bare act of the Indian Penal Code with you. Do have bare act as far as the Indian Evidence Act is concerned, and also in case if it is possible, do refer to the provisions of the constitutional law is concerned. Now, to begin with, let us start to know what is this Criminal Procedure Code. As usual, to know the provisions of the Criminal Procedure Code, we shall be starting right from section 1 and go up to section 484 sections of the Criminal Procedure Code, and you must be in a position to master all the provisions for the simple reason that this is a procedural law. You must be in a position to correlate one section with that of the other section, and it is only because of reading the sections together it will be possible for you to know the importance of it, with which I shall be dealing during course of my lectures. So 484 sections, yes, I mean each section is of equal importance. Each section you must know, then only it is possible for you to understand the provisions. Does it mean that it is necessary for you to remember the section number? Is it necessary for you to remember the section as it is written in the book? Certainly not. You must be in a position to read the section. I mean, you should read the section. You should analyze the section. You should carry out dissection of the section and try to understand what are the ingredients with the help of which it is possible for you to make your fundas very clear as far as the understanding of the Criminal Procedure Code is concerned. So now, once we start dealing with the provisions of the Criminal Procedure Code, as I told you, we shall start right from section 1 and go up to section 484 of the Criminal Procedure Code. For ready reference, do not forget to have bare act of which are the other books. I shall let you know during course of time. But bare act is a must for each who wants to master the provisions of the Criminal Procedure Code, of which you should take serious note as far as my part 1 or this part is concerned, where we have started learning or understanding Criminal Procedure Code. After 484 sections of the Criminal Procedure Code, we have first schedule of the Criminal Procedure Code. After first schedule of the Criminal Procedure Code, we have second schedule of the Criminal Procedure Code, and that shall be, first of all, right in the beginning, we shall try to understand the importance of the second schedule of the Criminal Procedure Code from the point of view of understanding Criminal Procedure Code, to have what is known as holistic approach from the point of view of understanding the law, and we will continue with the same as far as part 2, as far as my lecture series is concerned.